immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar by immigrationquestion.com, a networking platform and meeting ground where individuals and licensed immigration attorneys engage, learn, and exchange insights on U.S. immigration developments. My name is Max Castro, and I'll be guiding you through today's important conversation, how new rules and changes affect family-based immigration applications. Over the past year, family-based immigration has undergone significant updates, from new documentation and financial requirements to stricter interview scrutiny and growing visa backlogs. These changes have created confusion and anxiety for many families hoping to reunite in the United States. Today's session will explain what has changed, what hasn't, and what you can do to prepare your application and protect your status. We're joined today by attorney Jacob Tuimaualuga, a U.S. immigration attorney with extensive experience in both family-based and employment-based immigration. His work spans from non-immigrant and permanent resident cases, including HLO and K visas, national interest waivers, EB categories, etc. He also advises on business formation and contracts for immigrations, helping clients build solid foundations while navigating the U.S. immigration process. Welcome, Attorney Tuimaualuga. We're thrilled to host again for the live stream.
Thanks, Max. Good to be here with you. Always a pleasure.
All right, awesome. Before we begin, here's a reminder. Immigration Question is not a law firm and does not provide legal advice, guidance, or representation. This platform serves as a public meeting ground for people who can learn about immigration topics and engage directly with licensed immigration attorneys who participate independently. Let's get started. Attorney Jacob, to begin with, can you walk us through with some of the most recent updates or policy changes shaping family-based immigration in the U.S.?
Absolutely. I would say I, like many of you who are in the immigration process, probably follow social media trends. It is a very odd time to practice immigration law. I would say, if nothing else, I never thought that I would need to check Twitter or X so commonly for government announcements. So there are several things that have changed substantially over the past year with family-based immigration. I would say number one is just an elevated scrutiny, a sense of heightened scrutiny for even marriage and family-based applications. In years past, it used to essentially be considered a rubber stamp if you married an American citizen or if you had a child who was over 21 who was a U.S. citizen. If they were to petition you, you basically didn't have anything to worry about. Now, it's at least possible if you file a petition without the adjustment of status application, and even if you are otherwise in status, you're likely to have higher level of scrutiny and have interviews and have to prove more than you would have in times past that you're qualified for a green card.
Thank you, attorney. And many families hear about increased documentation requirements and longer processing times. What drives these changes, and what practical steps can applicants take to avoid unnecessary delays?
Yeah, I would say a lot of the delays or the process are because USCIS has had to change a lot of their processes. One thing that they do frequently that delays things are, one, change the form additions. So when you're filling out an application, the forms may look the same, but if there's a different barcode or addition date on the bottom of the form, they're going to reject it. They're not going to process that. And they have been changing them quite frequently in the past year. So that's one thing to watch out for. Another thing is they have changed the manner of how payments are made on immigration cases. So in times past, you could just submit a cashier's check, a money order, or personal checks. As of yesterday, that's no longer possible, or as of this week, that's no longer possible. Where now you have to submit a credit card or bank authorization form. Those are just two examples of changes that USCIS has made. There's honestly dozens of other ones that I could talk all day about, but I would say overall, now more than ever, it's just important to check what the current process is, because even if you had a friend or cousin or whoever that went through this last year, it's different now. That's the truth.
Thank you, Attorney. And how have these new rules affected petitioners and beneficiaries who are waiting abroad, especially regarding visa availability, interviews, and consular backlogs?
It's really odd. I've seen faster processing times for those who apply in the US, but much slower from abroad. So I practice here in Utah, and I've had multiple marriage and family cases, like from start to finish, that had their green cards, like start mailing in until green card in hand in less than 5 months. We had a couple that were 2 months. This is not possible at all if you are abroad. So right now we have multiple cases that have been processing at least 2 years, who are married, for people who are married to American citizens, or their children are US citizens, and they're still just waiting for appointments. And I think there's a couple reasons for this. One is that there's multiple government agencies involved. And then I think two is there's just not as much demand, I suppose, or not as much pressure from people who are outside the country as those that are here for them to take action.
Understood. Thank you so much. And some applicants are concerned that the public charge reviews and financial sponsorship rules are becoming stricter, just like you mentioned from your question. Can you explain what families should know when preparing the affidavit of support and other financial evidence?
This is definitely the case. In years past, as long as you had a sponsor that satisfied the 125% of the federal poverty guidelines, you were going to be fine with the public charge or the affidavit of support. Now, that's still the case for the affidavit of support. So if you're filling this out, just Google I-864P and check out the household size. So this should count everybody that's in your household, counting the immigrant. And as long as the petitioner makes at least 125% of federal poverty guidelines, you're good. Now, public charge, the problems with the public charge are that if the government thinks you're likely to need welfare, essentially federal cash benefits, they're not going to approve your application. So in times past, that basically just meant, hey, if you've ever had like food stamps or welfare, like you actually got money from the government, those would be disqualifying. Now they ask you about your assets, your liabilities, your income level. They ask about your education, your professional background. And all of this is on the forms. And if they think based on the information you filled out that you are likely not going to be able to pay for yourself, you could get your case denied. So if you're working on this, I would consider getting a joint sponsor if you're on the fence. And then second is to be confident in how you answer the questions concerning your financial situation. Make sure you can clearly communicate to an officer that you can support yourself. That's going to be the most important thing.
Thank you, Attorney. And we've seen shifts in how USCIS and consular officers evaluate marriage-based petitions and adjustment interviews. What common mistakes do you see families make during this stage, and how can they best prepare for this?
Oh man. Okay. This is a good question. I would say the most common mistakes are usually result in getting rejection. So a lot of times I have people who are young or don't have a lot of money to pay for an attorney, which I understand, but who will fill out the forms, and whether it's the addition date or the petition number or priority date, or they're just missing a required form, when they mail it in, USCIS will just reject it. They'll just mail it back to the applicant and say, you didn't send this to us correctly. I don't actually think that's the end of the world, because you're not going to lose any money. They're not going to cash your check, or they're not going to cash your payment if it gets rejected. Now, the problem is if you fill out or you say something on your application that gets it denied. So for example, if you don't understand the questions and how you've answered them, and let's say that you confess or you admit to a violation that you've never actually done, but you didn't understand the question. At that point, not only could immigration deny your application, so you lose your filing fee, which could be thousands of dollars, but second, it's now possible that they could send you something called a notice to appear before an immigration judge, basically to put you in deportation proceedings. I'm not one of these attorneys who likes to play on people's fears. I think, honestly, for a lot of people who have straightforward cases, it's not incredibly difficult to do this process by yourself. But I think it's worth an investment just to get it checked at least before you send it in, especially if you have any, let's say, special facts or circumstances in your case.
Thank you so much, Attorney. And to everyone joining us live on Facebook, YouTube, LinkedIn, and other platforms, thank you for being part of this critical discussion. Whether you're a U.S. citizen sponsoring a loved one, a permanent resident planning for adjustment, or a family simply trying to stay informed, this session is here to help you understand more options and prepare with confidence. If this is your first time joining us, welcome. ImmigrationQuestion.com is where immigrants, families, and employers can ask immigration questions for free and network directly with licensed attorneys. You can ask your question in any language and receive answers. Many users may also qualify for a free confidential consultation. We also wanted to mention, and we're proud to share, that Immigration Question is now BBB accredited business, underscoring our commitment to transparency, honesty, and service to the immigrant and business communities across the United States. Attorney Tuimaualuga, as an immigration attorney with extensive experience in both family-based and employment-based immigration, what are your thoughts on how a platform like Immigration Question is helping immigrants and attorneys network effectively?
Yeah, I mean, I think it's a great platform. I think it's a great resource. I love things like this. I think in times past, attorneys, just to be honest, I think could gatekeep a lot of information. I mean, I think about myself. I have a lot of experience. My firm processes hundreds of cases per month, so I can see what's happening. But also it's nice to kind of have that data, that experience democratized, because although I have a lot of experience, I think thousands of people who are also participating in this at the same time have more experience collectively, just based on each other's own experiences that they're sharing and reporting. I also think it's nice to help people on their journeys, for those who don't have the resources to hire a traditional attorney or traditional law firm, that they are not prevented from having quality guidance or quality resources. I think Immigration Question provides that for them.
Thank you very much, Attorney Jacob. We really appreciate that. And before we move on into our live Q&A session, one last question from me. For mixed status or multiple generational families, where some members are U.S. citizens and some are not, what long-term planning strategies would you recommend to help them stay compliant and united under the new framework?
I actually think this is probably the most complicated question you've asked for so far. And I think that this is more complicated now than it has ever been before. So just to be honest, in times past, for mixed status families, usually a lot of the time the strategy was have a petition filed for the person who's out of status, and then have them essentially stay out of trouble until that petition is ready to process for a green card. Right? For a lot of people, especially if you've entered without authorization, or if you've fallen out of status and you're not married to a U.S. citizen, you are going to require something called an unlawful presence waiver. Basically, you have to apply for forgiveness for violating your status. In years past, it's still possible now, you could apply for this forgiveness while you're here in the country. And then after it gets approved, then you could leave the U.S. and get your visa abroad and come back. And it should be a relatively quick process, around a week or two that you would need to be gone. That's just general language there. Now, it has been widely reported that now, even just by filing the petition, which is basically just the request to validate a family relationship for a green card, it's not even the actual green card change. Just by filing that, if you're out of status, could lead to you getting put in deportation proceedings. And that's never been the case before. So now more than ever, it requires a lot of strategic oversight and high-level decision-making to decide whether it makes sense to take the risk and file these petitions, or whether it makes sense to wait until there's changes in administration, if there is. Because there's also risks to the petitioner, to the American citizens, if you file this paperwork unsuccessfully as well. So yeah, a lot of changes, unfortunately and fortunately.
Thank you for enlightening us, Attorney. And if you're just joining us, we've been having an informative discussion with Attorney Jacob and how new rules and changes affect family-based immigration applications. We're now moving on into our live Q&A. This is your chance to ask your questions directly to a licensed immigration attorney. You can drop your questions in the chat or call us live at 516-703-3483. That's 516-703-3483. And we'll take on as many as time allows.
I'm down. Any questions you guys have? If not, it's all good.
Oh, there you go. So we have one from Benny. They're asking if I just want to know if they deny my I-485 now, will they report me for removal straight away?
Hi, Benny. It's a great question. All right. So if you have your I-485 denied, will you be reported to immigration court for removal? Yeah. It may not be right away. I'll just share with you anecdotally. I've had clients who are married to American citizens, have straightforward cases, who have had their I-485s denied incorrectly. Let's say they were unable to make the interview date, or USCIS claimed they didn't receive a document that they did in fact receive. And then the immigration court still sent a notice to appear. If that happens, it's still possible for you to get your green card, to apply for adjustment through the immigration court, whether that's directly with them or if the court dismisses proceedings against you. But it's quite likely, if you have your I-485 denied, you will be referred to the court for removal proceedings.
Thank you, Attorney. Let's try to wait for more questions. Okay, we have from Rashida. I hear that even if petition is approved, they can still deport someone. How is that possible?
Yeah, this is a great question for Rashida. The reason why this is possible is because you should think of a petition and a status as different things. So the way I like to explain the petition is essentially like an anchor or permission for a visa. You can't get a visa or the green card without the petition, but the petition itself doesn't give you any status in of itself. So for a family-based petition, that's the form I-130, and if it's for employment, it's I-140, right? So those are the forms that you file. So when you get that approved, I mean, we're still going to celebrate, because you can use that essentially to redeem it for a visa or a green card, but you still have to file additional paperwork in order to get the visa. So if you're here in the country and you file an I-130, or you have, let's say your husband or wife file this, you have to file an I-485 to get your green card here in the States. If not, the Department of State is going to tell you, hey, congratulations on this petition, your I-130 petition. You need to come back to your home country and have an interview. And then you would file a form called a DS-260 to do that. So that's why the petition is different from a status or from a visa.
Hopefully that helps, Rashida. Okay, let's try to wait for a couple more questions. We have one from Nadia. She's asking, my petition was approved but not yet scheduled. Will the new rule make me start over?
This is a good question. It depends on the type of petition that you have. If it's from a family member on your behalf, you shouldn't be required to start over. I'm assuming that you're referring to the new rules with sponsorships or with the affidavits of support. You wouldn't have to start over because your petition is still valid. The only way, or I shouldn't say the only way, the most common way for people to lose their petitions are if they do not communicate with the National Visa Center for a long enough period of time. So let's just say you wait around, you get busy, and you don't move forward with your case. After 1 year, the National Visa Center will contact you and say, hey, we're going to cancel your case if you don't complete your paperwork. And then after a second year, if you don't do it, they will cancel your case. And then you have to file the petition over. So as long as you don't run into that, make sure you move your paperwork forward, you should be okay. Sweet. Yeah, if there's no other questions, Immigration Question is a great platform, a great resource. There's so many answers available online. I see how many attorneys, I know myself included, love to participate and provide feedback on there. So I'm sure a lot of your questions, if you have any more, you can definitely feel free to post them on there.
Highly appreciate it, attorney. And thank you for sharing your insight on this very timely topic. Your breakdown of how new regulations reshape family-based immigration has given many families clarity and direction in these uncertain times. And to all our viewers, thank you for joining us. We hope today's session helped you understand what's changing, what's expected, and how to stay proactive as you prepare your applications. Remember, you can always visit immigrationquestion.com to ask your immigration questions for free and engage directly with a licensed immigration attorney. Many users may also qualify for a free confidential consultation. If you missed part of this discussion or want to share it with others, the full replay will also be available on Spotify. Just search Borderless Talk by immigrationquestion.com to join us again tomorrow for another in-depth session on the policies, opportunities, and challenges shaping the future of immigration in the United States. Once again, thank you, Attorney Tuimaualuga, and thank you for everyone watching. Until next time, stay informed, stay connected, and stay engaged.
Thank you, everyone. Have a good day. Bye, Max. Thank you.
Very nice meeting you, Attorney. Looking forward to the next time.